Small Business Administration for the western part of Pennsylvania. And she's the one who organized this. So thank you to Karen.
Well, thank you, Tom and Brittany. I really, really appreciate this collaboration between our offices to bring informational trainings on valuable resources and subjects. You know, SBA's mission for the past 68 years and into the future has always been and will be to help entrepreneurs and small businesses start, grow their business, expand their business, and even recover from disasters. And a lot of this is handled through all of our programs and services. In the next few slides, I just want to highlight just a few of the ways that SBA is here to help. With this first, you can go back to that next slide. Thank you, Brittany. You know, one of the ways we're here to help is by providing free and confidential business consulting, you know, through SBA's valued resource partner network. You can see our 8 small business development centers. We have 3 SCORE chapters. These are mentors that provide real life experience because they've worked in corporate America. We have one located in Pittsburgh, one at Westmoreland, and then one in State College there. And we have a women's business center, and they all cover that green shaded area because we're the Western Pennsylvania district. You know, our Philadelphia office is highlighted in yellow there. And if you're in another state by chance listening in, please know that SBA has offices in every state, and we have resources there to assist you as well. So if you go to sba.gov, under local assistance, if you plug in your zip code or an address, you can find the closest resources to you. And our resource partner network, you know, they offer that free and confidential business consulting. They're like an extra set of eyes and ears trying to listen to you as a business owner, what you're trying to do with your business, where you want to take it. And like I said, most of their services are free, and you would be surprised at some of the services they offer, especially if you're a startup helping with that business plan, or if you're seeking funding. They can assist you with your financials, your projections, and all of our resource partners offer this service. You know, feel free to explore their websites. They have a lot of good information. The next slide, Brittany. You know, also, we're here to help you grow your business, and that's typically through access to capital. So we're here for your financing needs if you're planning to start a business or grow. You know, whether you need a few $1,000s or a few $1 million, SBA has a lending program for your business needs. You can also utilize SBA's free online lending platform, Lender Match. You know, this is a good way to connect with SBA lenders across the country. You know, Lender Match is on SBA's website. You can simply answer probably 10, 12 questions about your funding need. And if a lending institution is interested, typically within the 48-hour period, they're going to contact you maybe to discuss your needs a little bit more, find out a little bit more about your business and you. On the next slide. So if you are an established business, maybe you're looking to find new customers. You can expand maybe by selling your goods or services to the federal government, you know, through one of our assistance programs. And also maybe learn about how to sell internationally, you know, because there's customers everywhere. You know, as the slide states, 95% of consumers really live outside the US. So we have resource partners experienced in exporting. Our office can help you with government contracting, looking for different ways to grow your business and find new customers. Next slide. You know, finally, this is our resource guide. You know, take a look at it. It is geared towards our 27 counties and with specific content and resources that you can find in our territory. All SBA offices have their own, so take a look at that if you are not in the Western Pennsylvania area. You can sign up for our email alerts by texting SBA to 468 888-311. And you can find out about what we're doing, such as our event today and other collaborations that we're going to be doing. Please view SBA's website, www.sba.gov, for everything related to business, or you can just simply contact me. Now, I'd like to turn the program over to Brittany, and she'll take it from here. Thanks, Brittany.
Thank you, Karen, and thank you again for all the work you've done with me behind the scenes and just collaborating with our clinic and helping us get the word out about our services and for all the services the SBA offers. So as we stated, today we're going to be talking about basic legal principles for startup companies. I'm going to begin by piggybacking off of Karen's resources and partnerships to expand that. As Tom, the director, Tom, said at the beginning of this, our clinic, we are located in State College, so like central, but we use Zoom. And so we are able to communicate and help assist clients all across the state. So because of that, we are partnered with a lot of economic development centers and government programs across the entire state. So on top of the programs and opportunities that Karen already discussed, some of these are repeats that she mentioned, but just so everyone knows, for specifically the small business development centers, as Karen explained them, there's 16 of them across Pennsylvania, 16 districts. Of the picture in the background you're seeing, the map is going to be the different, where the different districts of services for the SBDC will be. So they offer, as she said, business planning and industry specific advice, marketing and operations help. And more than that, honestly, if you go on their website, they also have somewhere you can type in your zip code and it'll show you the closest SBDC to you. And again, they're free of cost as well. And then our clinic is part of Invent Penn State. So across the state of Pennsylvania, there's 21 innovation hubs and 16 launch boxes. So the launch boxes have accelerator programs for new and startup businesses. And the hubs are they're open co-working spaces, which provides an area for community members, not just Penn State people, to come in and have a place to work. Finally, we also do a lot of work with Ben Franklin and technology partners. Specifically, we work a lot with the Central and Northern Ben Franklin, but they, again, another accelerator program. So there's a lot of services and free assistance out there that we really suggest and recommend that our clients get in touch with and get in contact with. As Tom said, our legal services, our clinic offers legal services. So for the business advice and things, we will go ahead and have you, typically if it's referred, our client is referred. Obviously, they're already working with one of these sources, but if not, we will suggest our clients get in contact with one of those services so that they can help with the more business specific advice. A little overview of how our clinic works and how to sign up. And to answer the Q&A, yes, this is being recorded. The recording will be sent out at the end, and also a copy of the slide deck. So all the links will be embedded in the slides. So for our clinic, as Tom already explained, we offer free or pro bono legal services for business-related legal issues. We work with small companies and startups across the state. So the process looks like a client submits an intake form online with the intake link that I'll have. So all the viewers will have at the end of this. Once we receive the intake form, the three, as Tom said, he's the director, and then there's myself and another staff attorney. So the three of us are, I guess, the in charge people. And then we work with students. So with the 20 students in the clinic, we have weekly meetings where we will assign clients to the students. Students have an intro meeting with the client. So that'll be done typically through Zoom or over the phone. That way we get to know a little more about the client's needs. And then from there, we'll draft up an engagement letter that will formally represent our engagement. So it'll lay out the types of things we are able to help you with and disclaim any services that we specifically wouldn't be able to help with. Once that's signed off on, then the formal representation begins and we go forward and help with whatever the client needs, be that forming a company or drafting paperwork or reviewing paperwork, whatever they need. So now that you know a little more about our clinic, thank you all again for joining today. The presentation will be on basic legal principles for startup companies. So an overview of what we're going to talk about today. First, we'll start with entity formation, looking at why, how, and when to form an entity. Next, we'll look at choice of entity comparisons. So we'll compare the different types of business structures that are available. Well, the most common ones. And finally, we'll look at some of the most common startup mistakes. We'll go through those, explain them, and say what you should do differently to make sure that anyone is avoiding these types of issues. And we'll end with some hypothetical and questions and have some Q&A time at the end. Starting with entity formation. So the first question we have clients ask most often is, should I form a business entity or do I even need one? And our short answer is yes, you should always form a business, especially in Pennsylvania. The filing fee is $125. So the liability protection that comes along with that, we always say is worth the $125, because the risk you're putting yourself at without having a business entity is far greater than $125. How do I form an entity? Well, formation is depending on the entity structure, but formation will require a filing with the state of Pennsylvania. That can be done online or you can mail it in. Part of the services our clinic offers is that we'll help you with the choice of entity, which best fits your business, and we'll also walk through the formation process with you. And last is, when should I organize an entity? The sooner the better. The sooner you get things written down, formally stated and officially documented, the better. So that way you don't have problems arising along the way, that maybe you started your company or you started with your best friend selling something you guys make and you've been doing good at it for a year. And then a year later you thought, hey, maybe we should have a company. Well, you're still, even though you never formed, there's issues that could have happened all along the way of that 1 year, that it would be best, and we'll talk about more as we go on through the presentation, that you would have formed your entity at the beginning to avoid any of these pitfalls. So to start off, we'll look at, with choice of entity, these are the different types of business structures that we're going to look through today. So we'll start with the sole proprietorship, which, as you see with the asterisk, is technically not an entity type, but it's a form of doing business. A general partnership, limited partnership. We'll look at corporations, both a C Corp and an S Corp, and talk about the difference of those. And finally, we'll talk about limited liability companies. The main considerations that we're going to look at and compare between the entity types will be how the liability regime works, the tax considerations, so whether the entity will have a double taxation or a pass-through taxation type. We'll look at the management and governance structures of the types. And finally, we'll look at the continuity and the exit strategies involved. So we'll start off with sole proprietorships. Sole proprietorships are recognized at common law, which means they're not a state creation and they're not created by statute. So there's no law, they're existing already. So that means formation, there's no filing required. So a sole proprietorship will exist immediately. The second that my example I often give clients is to think about it like a lemonade stand. I make the lemonade at my house, walk to the top of my street, and I start selling it to my neighbors. So once I'm selling this, even though I haven't formed any company or anything, because I haven't formed a company or anything, I'm operating as a sole proprietor. So here, personal liability is unlimited. So a sole proprietorship, because it's not an entity, does not provide any liability protection. So say there's a mishap with my lemonade and I end up hurting the customer. If they sue me, they would be able to sue me for all of that I own, all of my personal assets. Tax structure here is, of course, a pass-through entity or pass-through taxation, because there is no entity to tax, meaning any profits and losses are just going to be I will personally be a tax on that. Management here is that the sole prop, obviously it's a one person. Just think of a sole prop again as that lemonade stand. Though I'm the only one here, I'm the only one selling, so I'm the only one in charge and I manage the whole thing. Ownership restriction, again, with the sole proprietor, of course, you can only have one owner. The duration of this is that the sole proprietorship just continues on until either the sole proprietor withdraws, or of course, if the sole proprietor dies or passes away, then it will cease to exist. So we often steer our clients away from a typical sole proprietorship. The real benefit, quote unquote, is it's free because it happens automatically. You don't have to pay any filing fees. But again, there aren't really any benefits that go along with a sole proprietorship. Most importantly, there's no liability protection, so all of your personal assets will be exposed. So from there, we'll look at a general partnership. So again, this is also a common law creation. So here, this means similar to a sole prop, a partnership can happen like a de facto partnership. It's almost like on accident, like you don't need to have filed anything. You don't need to have official paperwork. So with this lemonade example, say one day my brother was home and we together decided, let's go to the top of the street and set up a stand. The second my brother and I were working together, we make our sale. That will define us as a general partnership, will be defined as an association of two or more persons to carry on as co-owners of a business for profit. So in that scenario, my brother and I are the co-owners of this business, regardless that we never wrote anything down. We don't even have to refer to ourselves as business partners or a partnership. We will be viewed as a partnership. Here, it's going to be the taxation process will be, again, this pass-through taxation. So there will not be any tax at the entity level, and instead it'll be taxed through the owners or the partners. Management is that in general, partners have equal rights to management unless otherwise agreed upon. So if the two partners do have a partnership agreement, you can divide the management differently if you so choose. But in absence of an agreement, partners are going to have equal rights to manage. Ownership, again, there's going to be an unlimited amount. You can have as many general partners as you want. And here the partnership may continue even if one partner exits. So this little thing at the bottom you see with a general partnership, all partners have equal management rights and have unlimited joint and several personal liability. So in this lemonade example, say my brother and I are working together, we're partners, no formal partnership agreement though, we're selling something and my brother maybe messes up and spills lemonade on someone's fancy new shoes. I don't know, something to this effect. This lady would, or man, whoever this shoe owner is, would be able to sue us. So in the worst part is they could sue, yes, my brother, but they could also sue me, and we would both be jointly and severally personally liable for up to however much the company or the partnership is being sued for. So important, again, here with why we typically steer clients away from partnerships is, again, there's not going to be any liability protection granted to the partners. So compare this general partnership to a limited partnership. Here, there actually is a formation or filing required to form. You have to file with the state the certificate of limited partnership. Tax structure stays the same. It will also be a pass-through entity or taxation structure. Management here, with a limited partnership, you're going to have two types of partners. You have one or more general partners and then one or more limited partners. Here, the general partners are going to be in charge and have the authority to manage the business, but they also will then have unlimited liability, as opposed to limited partners who have virtually no management authority, but they also have no liability above their original investment. So this is really thinking about situations with like a passive investor where someone's maybe not working and making everyday management decisions. So that limited partner is maybe investing funds, but isn't every day doing things. That limited partner then wouldn't be liable for anything more than what they invested in that company. Here again, it's an unlimited number of general partners or limited partners can be in a limited partnership. So then on the opposite end, if partnerships on one end, we have a corporation on the other end, where a corporation is, again, also has a filing required for formation. So in Pennsylvania, you file the articles of incorporation with the state. That's a $125 filing fee. So I mentioned at the beginning, two types of corporations. It's all going to be a corporation, and then you'll make an election for tax purposes as a C Corp or an S Corp. So regardless, we'll get to that next, but regardless of this election, all corporations are going to have this general governance structure. So it's easiest to think of it in three separate groups. So first you have the shareholders. So shareholders are effectively the owners of the corporation, but they're not making really any decisions. So it's very important to note here in a corporation that ownership is separated from control. So the shareholders own the corporation and they appoint the board of directors. So the board of directors then oversee the management of the corporation set the corporate policies, and they elect the officers who oversee the day-to-day decisions making of the company. So these officers, importantly, are answerable to the board as opposed to the shareholders. So in a corporation, really, the board of directors is holding the power, and they're setting policies and electing officers to follow whatever policies they're setting. And then it's also the job of the board of directors to oversee and monitor the officers to make sure that they're doing their job appropriately. So like I said, that governance structure applies to both either a C corporation or an S corp. So now we'll look at the difference between those two. So starting off with a C corporation. So a C corporation, again, or importantly here, is that all corporations really are going to have this limited liability protection offered to the owners. So that way, if something happens and the corporation is sued, the shareholders and owners cannot be sued individually. They can only the corporation can be sued. So for whatever assets the corporation holds, that can be touched. But me personally, for instance, if the company holds $100,000 and it's being sued for $120,000, and I own in my personal life, a jet ski or something worth $20,000, they couldn't just come to my house and take my jet ski because I'm personally protected from that liability. So ownership in a C corporation is unlimited amount of shareholders, have as many as you want, and there's not a limit on the types or the classes of stock you can issue. And the big point here is that a corporation, the taxation structure here is going to be the double taxation. So as you can see on the image at the below, income comes into a corporation and it'll be immediately taxed. That's taxable income there, and it'll be taxed at the corporate rate. So for now, that's set at a 21% flat corporate tax rate, tax off the top. Then in the event that any of that income from the corporation is distributed to investor shareholders, it again is taxed once it comes to the investor shareholder at their personal income tax level. So this has the double taxation effect, where it's first taxed at the corporate level and then taxed at the shareholder level. Important to note for startups, this double taxation issue is not always an issue because the problem with double taxation is only as far as to the extent that the company is actually making distributions. So if the company instead is just holding on to the money and reinvesting it into the company, then there won't be that distribution to individuals. So there won't be the second double taxation. You're only going to be taxed at that first 21% corporate flat rate. So it becomes an issue when a corporation is making distributions to shareholders. So compare that structure of a C corp to an S corporation. So again, corporation is the legal entity you form, and then you're going to just check an election for tax purposes to be taxed as a C corp or an S corp. So here, if you check the box to be taxed as an S corporation, again, same thing with the limited liability. You are personally not going to be liable for the debts of the corporation. Here, though, it's the ownership and tax structure that are going to differ with the C corporation between a C and an S. So with an S corporation, there's a limit. There has to be less than 100 shareholders in total. The corporation has to be domestically incorporated. And then of those 100 shareholders, they have to all meet certain eligibility requirements. In short, that just means shareholders have to be individuals. It could be specific trust or an estate or certain tax exempt organizations. In normal people words, that just means a partnership, a corporation, or a non-US citizen cannot qualify as an eligible shareholder of an S corporation. Finally, the other restriction in ownership is that an S corporation only has one class of stock. And then here, the S corporation tax structure is going to be the pass-through as opposed to that double taxation issue. So it is not taxed at that corporate level. It instead is taxed at the shareholder level, similar to the partnership we discussed at the beginning. So now on to the last option, which is also what we usually recommend for most of our clients, is going to be the limited liability company. So here there is a filing required with the state, and that'll be in Pennsylvania. Again, also just a $125 filing fee for the certificate of organization. So LLCs are known as a hybrid entity because they take parts of other structures and combined to be the kind of the best version of it. So with this hybrid entity, you still have the pass-through taxation benefit, and you have the limited liability structure. So owners of an limited liability company, again, are not going to be personally liable for debts or obligations of the LLC. It's going to be a pass-through structure. So again, it won't be taxed at the LLC level, and instead it'll be taxed through to the members. Management can look different. If it's a single member owning an LLC, if there's only one person owning it, then of course you by default are a single member LLC. If there's multiple people in the LLC, then it can either be member managed or manager managed. So a member managed LLC is again similar to this general partnership where all members are part of the management, and in the operating agreement, which is like the internal document of an LLC, the members can designate membership units or like membership interest units into the different members. So if my brother and I formed an LLC here as member managed, maybe we're both 50% owners. So we both have 50% decision power and authority over the decisions of the company. Compare that to a manager managed LLC. And that is usually where there's one member that's more involved and one member that's going to be more passive, similar to the limited partnership as opposed to the general partnership. But here, not to be confused, because everyone still gets that limited liability protection, even in a manager managed LLC. There you would just designate one member to be, or more, to be the managers of the LLC. So they have authority and decision-making powers, and the other members would maybe have the economic right if there's distributions or something, but they're not making everyday decisions in the company. And again, finally, with the LLC ownership rights, there's going to be an unlimited, you can have as many owners and members in the LLC as you want. So now that we have discussed the different types of entity structures and you know the importance and why you want an entity, we'll talk about some common startup mistakes. First, we see very common is starting a business while you're still employed by a potential competitor. So this brings up a lot of potential issues. First and foremost, looking at you taking confidential trade secret information and using it in your new company. So for an example, imagine something with a long-standing business relationship, like a janitorial service for an office building. So say I'm part of this, I leave the firm I've been working for and I start my own janitorial service. It would be I would be taking confidential trade secret information if I were to take the customer list from my previous employment and then in my new business called up my old customers saying like, hey, you remember me? I'm still doing business and I'm back. How about you take me instead? Using and relying on their customer lists or business plans would be taking confidential trade secret information from your employer, which would expose you to liability. Importantly, also, it's important to note because this is not a standard across the board, it would be important to note what fiduciary duties you owed in your last position. And it's also important to note in your potential, when you're currently employed, whether or not you have any non-disclosure agreements that have been signed or any covenants not to compete, because that would limit what you're able to do while you're employed and even after you're employed, in many cases after you're employed. So non-disclosure agreements, if there's things you're not allowed to obviously disclose. Additionally, if there's covenants not to compete. So if I quit my painting job, for instance, and then started up a new painting firm right down the street, if in my previous employment contract, I had this covenant not to compete, or while I'm still employed, more importantly, if I have a covenant not to compete and I go down the street and start up a business, that's going to expose me to a lot of liability. So again, to avoid these issues, we'd want to make sure you read through your employment agreement and verify that you don't have any non-disclosure NDAs or covenants that you may be violating when you're starting a new company. So it's best to get advice on that before you go too far. Another common agreement is a failure to record agreements and contracts between initial founders and initial members. So a good example of this, if you've seen the Social Network movie back in 2004, I guess before that at Harvard, these Winklevoss twins and one of their classmates worked together to create some type of social media network called, I think, Harvard Connect at first, and then they later changed it to Connect You. During that time when they're building it, they reportedly hired Mark Zuckerberg to come in and create some type of source code for their specific Connect You website. Later, Mark Zuckerberg, as we know him now, went on to create Facebook. So in 2004, the Winklevoss twins sued Zuckerberg, alleging he broke an oral contract between them. And the suit alleged that Zuckerberg had, one, copied their idea, and two, illegally used source coding intended for the Winklevosses website that Zuckerberg was hired to create for the Winklevosses. So again, the big issue here is all oral. They all talked about it. They thought this sounded great, and then they got to work. Years later, Mark Zuckerberg creates Facebook as we know it. And imagine, animosity, but also frustration you would feel of seeing that your idea or something you hired someone to do, they went off and made it bigger and better and a lot more successful. So important for founders agreements, for founders to write down their terms sooner the better, as we've been saying. A founder agreement should include each owner's roles and responsibilities. It should specify how the equity will be distributed. It should have mention of exit clauses of what happens if someone tries to leave, or in the event that someone wants to sell the company, who has that ultimate authority. So there's a lot of issues that, again, one of the biggest mistakes here that we see most often is that people wait too long to consider these questions and ideas, and they wait until it's too late and the issues already arose, where they should, before they get to that point, have already established all of these in some founder agreements, which one of the services our clinic offers, as we've stated a lot now, is talking through the different issues that could arise and helping you understand what should go into your founder agreement. Okay, and then this final issue that we'll talk about, or mistake, is going to be issuing founder shares without vesting. So vesting is going to be earning the equity over time. So the problem here, imagine a situation where there's two co-founders, whatever. Co-founder one receives 30% equity of the entire company on day one. And then on day two, co-founder decides, I no longer want to be here, so I'm just going to walk away because I already own 30% of this company, so I'm out. Solution here is to create a vesting schedule to allow this founders to receive their shares over time. So instead of getting all 30% right now, maybe you'd get 10% each year over a span of 3 years. Problem with vesting is that equity subject to vesting is taxed at its fair market value each vesting period. So that becomes an issue if the value of the shares increases over time. So for instance, in that example of the co-founder receiving 30%, say they had agreed that he would receive 10%, it's easier to not use percent, sorry. Say he's going to get 300 shares in total. Say they would give him 100 shares per year for 3 years. In year one, maybe the fair market value is only $10, but in year three, the fair market value of that share could be $1 million. And so with vesting, without making this 83B election that we'll talk about, under normal circumstances, in that third year, I'm going to have to pay the fair market value or tax on the stock at the fair market value at the $1 million price of the shares, as opposed to the $1 or $10 share that it started at the beginning. So to avoid this issue, we recommend the 83B election. So here, similar scenario. So imagine there's a total of 1,000 shares that you're going to get. So in one scenario, it would vest, or both, I guess. In this scenario, it will vest over time. So for over 4 years, you're going to get 250 shares each year. So at each vesting period, it'll be subject, you'll have to pay tax subject to the fair market value of whatever the shares are valued at that time that the vesting period comes. So in year one, in this hypothetical, say fair market value of the shares is only $250. So you're going to pay, assuming a 37% rate, you're going to pay $92.50 for that in year one. Then again, maybe the price hasn't increased, it stays at that 250 level. So you'll pay the same amount of tax, the 92.50 in year 2. But year 3, your company expanded a little and now it's worth a lot more. So now say your fair market value of the shares is 250,000 as opposed to just 250. So now, as you can see in the chart, I won't go through it all, but you can see each year you're going to be paying exponentially more money in taxes, where instead of having to pay them at the time they're due over the vesting period, you could at the beginning, you have to do this within 30 days, is an elect the 83B election. So this would be, I'm going to go ahead and pay the tax on the fair market value of all of the shares at the very beginning. So this way, in year 1, you're going to go ahead and pay that 37% tax on all 1,000 shares, as opposed to breaking it down and paying 4 separate times. So here at the year 1 level, say it would be all the shares would have, all 1,000 would be the fair market value of $1,000. So in total, you'd only have to pay $370 in tax for the entire value. And again, compare that just to the line right above, where if you'd waited and had to pay each year as it vested, you'd be accruing a lot more in liability that you'd have to pay. So then by the year 4, you'd be paying $185,000 just for that year's vesting. Okay, so that really concludes the substantive portion of the learning part. So now we're going to go, I have already put together this hypothetical so we can talk through it and talk through some potential questions, and then we'll get to a Q&A portion. So here we have, imagine a scenario where Mary and Larry open up a bakery in Western Pennsylvania, which they call M&L Baked Goods. They open up a bank account, and the bank requires them to file for a fictitious name, also referred to as a DBA. And so they get the fictitious name for M&L Baked Goods in order to have the bank account. They don't do anything else to organize the business. A few months later, many of their customers get food poisoning due to a mistake that Larry makes in their muffin recipe. The sick customers hired a lawyer and sue Mary and Larry, and their lawyer says that she could settle the claim for a $4 million amount. Assume that, unfortunately, they did not purchase any product liability insurance. So in this scenario, question 1, does the registration of the fictitious name protect Mary and Larry from personal liability? Here, no, the fictitious name provides no protection for the owners of the business. So just because they filed and they do business as M&L Baked Goods, that really means nothing, because they both are going to be personally liable for the amount, the $4 million settlement. Do Mary and Larry have a business entity, even though they did nothing other than file the fictitious name? Think on it. Not an obvious answer, but yes, they do have a business entity, even though they didn't file anything, because as we discussed earlier, they would have what's called a de facto partnership. That's going to be a general partnership. And so in the same example of my brother and I selling lemonade, even though we didn't call ourselves partners and we didn't make an agreement, we are effectively a general partnership. Same here with Mary and Larry. They've been working together selling baked goods, so they're an effective de facto partnership. So in this scenario, imagine Larry has pretty much no money, but Mary has a $2 million investment from her grandmother investment account, that she inherited from her grandmother. What is the maximum amount for which Mary could be personally liable? Here, Mary, it's the same scenario where they're being sued. The settlement amount is $4 million. Here, Mary could be held personally liable for all $4 million, because in the general partnership, you're jointly and severally liable. Does it matter, or does it help Mary's situation that Larry is the one who made the mistake? No, that actually would be irrelevant in this scenario, that Larry's fault wouldn't be taken into consideration. Each Larry and Mary would be liable for the total $4 million and the plaintiff or the sick person would be able to collect that from however or whoever they want amongst the two. Important to note, in this situation, if Mary was sued for all $4 million, she would have the right to recover from Larry. But if he has no assets, that's Mary's problem, not the plaintiff's. So here, imagine same scenario, but Mary and Larry managed to settle that dispute, the lawsuit, and they also stay in business. And now they're a little smarter and they said, hey, we shouldn't do that again. Let's not expose ourselves. Let's go ahead and file and form an LLC. So they form an LLC, call it M&L LLC, and they own it equally. They continue to operate the business for several years. It's going successfully. And Larry surprises Mary by telling her, I'm moving to Mexico, but I want to retain my 50% interest. First question, can Mary force Larry to surrender since he will not be working? Here, no, Larry cannot, or Mary cannot force Larry, assuming that there's no agreement made between Mary and Larry, that there's no operating agreement, then Mary cannot, by default, force Larry to surrender. Additionally, part 2, can Mary force Larry to sell his interest back? And if so, at what price? No, Mary cannot force Larry to sell his interest back. This could be solved if in their initial, again, the importance of founder agreements. If between Mary and Larry, they had an agreement with put or call options, then they would be able to force, either here, Mary would be able to force Larry to sell back his interests, or in part 3, question 3, can Larry force Mary or the company to buy his interest in the company? And if so, at what price? Again, with no agreement, no, Larry can't force Mary and Mary can't force Larry. They're both stuck. So it's good, again, and that's the important reason of why you should have these agreements and why you should have exit strategies built in at the beginning. Finally, again, same answer. Can Larry force a liquidation of the company in order to get a share of the value of the assets? No, again. But note, all of this could have been avoided by just having an agreement between the members that deals with these issues. Okay. So assume further, Mary and Larry agree that Larry is leaving and they work together to create an agreement for the LLC to buy out Larry's shares. Mary needs money and a bank wouldn't give her a loan, so she goes to a personal relative. Say Mary approaches her Aunt Gladys, who has a lot of money. Aunt Gladys is willing to invest $200,000 into this LLC. From Aunt Gladys's standpoint, what would be the best form of investment into the LLC? A little bit of a trick question because we didn't talk a ton on investment strategies here, or forms of investment. But here we would say Aunt Gladys would probably do best with a convertible note. That would entitle her to a minimum rate of interest, but also give her the ability to convert the note into equity interest if in the event the LLC was being sold or otherwise it was preferred to have equity. So in this scenario, Aunt Gladys, it would be best for her to have a convertible note stating the interest at which she'll be repaid on her loan. And then in the event, say a few months in, Mary's making her payments back to Aunt Gladys, but 3 months in, Mary is approached by a big investor who offers, I'd love to buy your business for $5 million. So at that point, this is a liquidation event of selling the company. Aunt Gladys would have the option to convert the money into shares and equity of the company. So at that point, when the shares are sold, the company is sold, Aunt Gladys would actually be able to make more money there as opposed to her return on just a note because she'd be part of the sale here. Important to note that in the scenario of a closely held private company, it would not really be advantageous for Aunt Gladys to get shares or equity in this company, again, unless there's some type of liquidation event. Because if Aunt Gladys were to say, yeah, here's $200,000, make me a 20% investor. Like that's all grand and well, but assuming this company likely is not making any distributions, Gladys now is a 20% owner of something that isn't worth any money to her. And because it's a privately held company, it's not like I can go on my stock website and just try to sell this around. It's not publicly owned, so I can't do that. And also, even if I found someone who's willing to buy this share, it's not going to be very valuable because what use is it? The shares aren't worth anything. So it would be the best, as we said, for Aunt Gladys to just do a convertible note, getting paid with a return of interest. And also in the event it becomes profitable, she could convert her interest into equity. Okay, so that concludes all the presentation materials. Now I think we have a good 10 or so minutes for Q&A. So there's a chat box. Yes, thank you, Karen, go ahead.
Yeah, I was going to look at it. We do have a question. I imagine family businesses can create a number of these sorts of issues.
Yes, I don't know what exactly issues we were talking about at 1236, but I imagine maybe not having a founder. If the anonymous person wants to specify in the Q&A what types of issues they're talking about. Otherwise, we can talk just generally that yes, in family businesses, it prevents a very awkward scenario where often we get a husband and wife or married couple that comes in and maybe it's too far along or something. They didn't write these down at the beginning. Same premise as a prenup. You assume at the beginning, you never think the bad is going to happen, so it's not worth it. What's the point of me doing this? But then it comes out later on, there's some mistake or your partner's been lying or whatever happens. That is where this issue is going to come up. And it's exceptionally awkward, again, in like a family situation where you're supposed to be close and have somewhat of it's harder to just walk away from the scenario in a family situation. So it's just as important. It's just as important or even more important to have the agreements documented at the beginning of the business venture. Also, Tom, if you ever have anything to add on, go ahead.
Okay. Go ahead.
There is another one. Distributing equity to the children is also a challenge.
Tom, if you want to talk.
Yeah, Brittany, let me take this, give you a little break. Whenever a lot of family businesses do this, where they distribute shares out to the children, if the company's paying dividends, distributions out to the shareholders, that's one way to sort of move money down, to the next generation. But you need to have an agreement. One of the issues that comes up sometimes is you have disparate family members owning a small portion, and maybe you have an older generation of people who own a controlling interest, but then they want to sell the whole business. They want to cash out and move to Arizona or something. But you can't necessarily drag the children along. They may say, well, that's okay. I want to. I like it just the way it is. So it's important to have an agreement. Just as an example, if you have an agreement among the shareholders, it can force everybody to go along if a certain percentage of the people want to do something.
The link apparently from Chardonnay, the link isn't working to do the intake form. Do you have another link, or can it be provided after the webinar?
I might be able to put one in chat right now.
Okay, thank you, Tom.
Go ahead and I'll copy the link we have here. But do we have any other questions here in the meantime?
Not at the meantime.
Okay. All right, so if I put this in here, I hope everybody will see the answer here.
Okay, we do have a question that came in. We want to be able to donate to nonprofits and host fundraisers with our businesses, LLC. Would you recommend we set up a nonprofit in parallel for these funds? Or what are the tax implications of pass-through donations? I.e., customer wants to donate extra $10 in addition to their product purchase. That was from Jenna.
Well, if somebody contributes, frequently they want to be able to deduct it for tax purposes. And you can only deduct contributions made to a nonprofit organization. So, it sounds like, you may want to have a nonprofit for donation purposes, but there's a big however. Having any sort of nonprofit organization that qualifies for tax deductibility that way is a huge hassle. The requirements that you have as a nonprofit entity are significant. And so you really have to have a high volume of donations before you would be able to justify the annual reporting expenses and things like that. So if you're not going to have a lot of contributions, I would not form a nonprofit. But we could discuss this further with you. But lots of people want to form nonprofits because it sounds like a nice thing to do, but it's a huge hassle. And sometimes to have a separate entity, people form what's called a public benefit company, which is I think most of the states have this. You could take an LLC or a corporation and give it, you can call it a XYZ public benefit LLC. And that way it flags for people that you're doing sort of public good, but people don't get the tax deductibility for any donations.
Another question came in. Why is a spouse of a sole proprietor not liable in the sole proprietorship situation?
Simply because they didn't do anything. A sole proprietor runs the business and incurs liability as a sole proprietor, and the spouse is not automatically liable for whatever the other spouse does.
Okay. That's all the questions we have at the moment. Let's see.
We have a follow-up on here about are the assets jointly held?
Correct.
If assets are jointly held, that's usually the reason why you can't go after somebody's home. Let's deal with a simple situation where you have a married couple and they own a home jointly. One of them goes off and has a car accident, incurs great liability. Well, the other spouse isn't liable for that. They weren't driving the car. And likewise, you can't go back and satisfy liability with the home that they own jointly. Only the individual assets are subject to a claim. So unless both spouses are involved, their jointly held assets would not be exposed.
Okay. No additional questions yet. Oh, if I see something just popped in, hold on. It said, thanks for the answer. Is a public benefit company essentially just naming convention, or is it a unique legal construct, or is that should be contract?
Well, it is. I think it's good to call it a naming convention. It's primarily a label you put on things. There are a few requirements that are imposed, so it's different than like a traditional LLC. Not dramatically different, but it's primarily. I often tell clients it satisfies the PR or public relations benefit of saying this is for the public benefit.
It's also important to note with the public benefit corporation or company, you have to have a specified purpose statement for your company. So in any formation, when you're filing the application for a company, you have to put your business purpose, and it usually can be very broad. But for public benefit corporations or LLCs, the specification or the purpose of the company purpose statement has to be something within certain specifications so that the state sees that you're actually offering a public benefit. And additionally, there are annual public benefit registration fees you have to pay. I think I can't remember off the top of my head, but there's maybe $100 something, maybe $70 to $100-ish filing fee that you have to pay at the end of every year, just to show you, because as a public company, again, the PR thing is that you're more transparent. Public benefit company, I'm sorry, you're doing something good for the public and you're also supposed to be more transparent than a typical company or corporation. So at the end of the year, you have to file an annual report just to show to the state your numbers and that you're not funneling out the money and not actually providing a public benefit. So that's something to consider, is that there's somewhat of an additional cost. Well, there is an annual additional cost with the public benefit companies.
Another question came in. Are B Corps different in different states?
Well, the B Corp is really a certification you get. It's similar to a public benefit company, and it's more involved. You have to get certification through an independent nonprofit company that does this. And we always tell clients it's way too much hassle relative to having a public benefit company.
Well, it's about 1 minute till. I don't see any other additional questions. You want to wait a minute or two?
We can, just while we're closing up, if there's any last questions, yeah, of course, go ahead and throw that in the chat box. Otherwise, I would like to thank everyone for coming out today and listening in. As I said at the beginning, this has been recorded, so we'll send out a recording of today and the slide deck to all of the registrants or people that registered for the event today. And so also you can forward that to whoever, if someone wasn't able to make it today and didn't get to register. So all those materials will be available for you guys. Thank you again to Karen.
There's one last question. Where is the link for the intake form? We'll be getting that out.
Yeah, I answered it in the chat, but maybe it went away in that.
It was from anonymous attendee.
Oh yeah, if you click in the Q&A, there's like an answered bubble. If you go there, that's where Tom responded back to someone earlier asked, and there's a link in the answered. Oh, and then I'm seeing a last question here.
Oops.
Main difference between S corporation and an LLC. Well, good question, really. Go ahead, Tom.
Yeah, a corporation has more formality than an LLC, and that's why we recommend an LLC in almost all cases. From a tax standpoint, they're taxed very similarly because they're both a pass-through organization.
Yeah, but the C Corp or S Corp will have like the different governance structure that we talked about, as opposed to the LLC just having the members being in control. All right.
Oh, so maybe one more.
Okay, the link isn't showing up for some people, it shows, but after this, like I said, I will be sending out the recording and the slide deck to everyone, and I'll be sure it's embedded in the slide deck, but I'll be sure to also just include the link so that it's easier for everyone to access it. So then, yes, again, I'd like to say thank you to everyone, and thank you again, Karen, for partnering with us and helping us with this presentation, our last one and future ones with the SBA. And thank you, Tom, the director, for coming in and presenting as well. And thank all of you for listening. And of course, we have our intake form, so clients or anybody can fill that out. We start back up. Our semester starts next week. So we'll have students back in the room and we'll be signing out clients. So we'll get back to you very shortly. And otherwise, if you have any questions, of course, our emails also are in the slide deck and I'll be sending it out. So if you have any questions, feel free to directly email us as well. All right. Thanks, everyone. Have a great day.